Ryan Busick, P number 84554. Mr. Busick, could you please state your name for the record?
Ryan Michael Busick.
Welcome to this case, where everything from bond conditions to community safety will be tested. Right at the start, Judge Simpson establishes the formalities by confirming names and case details. This may sound routine, but in legal proceedings, misidentification can cause serious procedural delays or even appeal issues later. Notice how the judge immediately grounds the record. This ensures there's no ambiguity about who is present and what is at stake. For defendants like Buick, the early moments are critical. They set the tone for credibility in front of the court. Here, defense counsel wastes no time requesting adjournment due to missing discovery materials, which are essentially the evidence files needed to prepare a defense. Missing evidence creates tension should the case move forward when one side is unprepared. Ask yourself, if the defense doesn't have the materials, how fair can the fight really be?
This is a date and time set for PCC.
And Your Honor, at this time, I've made a request for the video and digital discovery in this that has not been tendered to me yet, so we'd be requesting an adjournment of the PCC.
All right, there would need to be a green sheet that would need, you may not be aware of that. We'll get you a green sheet to fill that out.
Sure thing, Your Honor.
All right.
Your Honor, just for the record, there was also, the media discovery has in the discovery packet and should be sent over to counsel, and then I also, I called yesterday, have not received that yet, but it should be in reference.
All right.
And Your Honor, we would like to address Brian when the court is ready.
Okay. You want the 26th or the 3rd, counsel?
Give me just a moment to check my calendar, Judge. The 26th would be fine if I could be accommodated, say at like 10 a.m. or later.
Well,
I haven't.
you'll likely be in more toward the afternoon, but I will set it at 9, and then we'll place you into a block. We noted what you've indicated, but
Scheduling battles may look like minor calendar conflicts, but they carry weight. Defense counsel requests a later time, knowing his other hearings could interfere. Judges, however, juggle dozens of cases daily. Notice how Judge Simpson strikes a compromise. He sets the case at 9 a.m., but acknowledges counsel's concern. This highlights a courtroom reality. Lawyers often run from one courtroom to another, and tardiness can mean missed opportunities to advocate for their clients. The subtext here is about power. Who controls the clock controls the case. The judge essentially says, "You're in my system. I'll set the time, but I've noted your needs." To the audience, this may seem procedural, but think about it. If you were the defendant, would you want your lawyer rushing in late, distracted from another courtroom? That's the human tension behind these calendar negotiations. Justice often comes down to minutes on the clock.
Very good. Yeah, I do have a
if he's
hearing.
in custody, you'll be in the 9 o'clock block, I will tell you.
Okay, I may just be tardy for court then that day. I'll be coming directly from Whitford.
All right, yes, that's about.
As to bond, while I know the court heard me 2 days ago, I would note that, due to Mr. Busick having no record, these last 2 nights in jail have left an incredibly strong impression on him. Not only the seriousness of this case, but the importance of following all conditions of any bond or any court order going forward. He would like to get back out working so he can save his health care for his children and for himself.
Here the defense pivots to humanizing Buick. Counsel emphasizes the psychological impact of jail. 2 nights behind bars can feel like a lifetime to someone with no prior record. This strategy is deliberate. It paints the defendant not as a hardened criminal, but as someone chastened by the system already. The mention of healthcare and children further tugs at sympathy, presenting Buick as a provider rather than a threat. The request for a reduced bond with tether and ankle monitor blends compassion with responsibility. He's learned his lesson, and will keep him monitored. But bond isn't about sympathy, it's about risk assessment. Judges must ask, will he show up? Will he reoffend? This is where the drama kicks in. Defense frames him as trustworthy, while the state insists he's already violated trust. Viewers, put yourself in Judge Simpson's position. Do 2 nights in jail outweigh prior bond violations?
He would like to pursue a mental health evaluation. I have talked to clinical therapists, one named Virginia Dawson, who works closely with many courts in Oakland and Wayne County, and she's worked with my office for years. She has experience at the 48th and 16th District Court. I've confirmed that she has appointments that would be available to him every single day next week, depending on his schedule. So we would accordingly renew our request for a cash bond that Mr. Busick can afford of $25,000, 10%, Your Honor, with the tether, obviously.
Response from the people.
Your Honor, I believe the court knows where the people stand on bond. At this point, I'm going to object, given the fact of the bond violation originally, and then the facts of this case. I believe the bond that is currently set at this moment is appropriate for this case.
The prosecution comes out swinging, flatly rejecting the defense's plea for leniency. Their stance hinges on history. Buick already violated bond terms. This point is critical. Bond is not just money, it's a contract of trust between the defendant and the court. Breaking that contract signals unreliability. The prosecutor's argument is not emotional, it's procedural and fact-driven. He's shown he can't be trusted. Why should we cut him slack? This strategy appeals directly to judicial caution. Notice the prosecutor references prior findings, reinforcing continuity, essentially saying, "We've been here before, nothing has changed." That consistency matters because judges want to avoid appearing inconsistent or soft on repeat violators. The underlying message to the public: bond is a privilege, not a right. If you breach it, you pay the price. Question for you: if someone already broke conditions once, would you risk giving them another chance?
Given all that was stated previously on the emergency bond motion, as well as the bond violations that came up as part of it.
And the court would incorporate its findings a couple of days ago addressing the emergency bond. The emergency bond filed on behalf of the people, and particularly noting that after the point of arraignment, the defendant's conduct, I don't think, would lead the court to believe that this defendant would be able to follow all of the conditions as set without some cash component or significant cash component in place to try to assure his compliance. And so, and also the court does believe, because of those actions, the defendant does pose a risk or threat to the community. And so therefore the court will deny the defendant's motion to reduce the bond in this case once again.
Would you consider a 10% provision on the current bond, Your Honor?
This is a fascinating tactical moment. Defense counsel, even after losing the larger motion, tries one last avenue, a 10% provision. This would allow Buick to post just a fraction of the full bond, drastically lowering the immediate financial burden. Judges, however, are wary of creating loopholes that undermine their earlier rulings. Judge Simpson immediately shuts this down. "You asked me that yesterday 3 times and the answer is the same." This response reveals judicial frustration. Repetition in arguments can backfire. Persistence looks like badgering rather than advocacy. The quick denial shows Simpson is not budging and values consistency over negotiation. To the audience, this feels like a courtroom standoff. Defense pushing boundaries, judge reinforcing authority. Think about it. When a judge repeats themselves, is it firmness or fatigue? Here it's both. A clear signal that Buick's legal options for bond relief are closing fast.
You asked me that yesterday 3 times, and so the answer is the same now.
Fair enough, Your Honor.
All right.
I hope you and your staff have a good afternoon. Thank you for allowing me to make a record, as always.
Thank you. So Bernstein said Judge Slade slow.
Oh.
No, I'm gonna call Judge Slade. I'm just calling.
It's a big packet.
I'm gonna call her and tell her what you said. If I have to make it up. Court does call the case of the people versus Wesley Brand.
Alexander, on behalf of the people.
Good afternoon, Your Honor. Wendy Barnwell, B42.
As the courtroom shifts to the next defendant, the contrast becomes evident. Brand admits outright to bond violations involving contact with a protected party. This is far more straightforward than Bung's contested arguments. Here the defense waives a hearing and accepts the violation, a move often aimed at damage control. The strategy: acknowledge fault quickly, minimize penalties, and move forward. But Brand's case underscores a deeper issue in bond law. Contacting protected individuals is one of the most dangerous violations, as it directly threatens safety. Judge Simpson's acceptance of the admission closes the matter efficiently.
Behind the scenes, detectives were piecing together a timeline so tight that even the smallest inconsistency could expose everything. And this moment, it was the first real slip.
But it raises a bigger question for viewers. Why would defendants risk direct violations when the consequences are so severe? Is it arrogance, desperation, or just poor judgment? This is where courtrooms turn into human theaters. Rules versus emotions, law versus impulse.
505 on behalf of Mr. Wesley Brand.
Your name, sir?
Wesley Brand.
All right. And this is the hearing that has been requested by the defendant regarding the violation.
Yes, Judge, my client at this time wishes to waive that bond violation hearing.
And he admits to the violations
Yes, Judge.
regarding contact with Tanya Wilson.
Regarding the phone calls,
Yes,
if that was the question.
yes.
Yes.
All right.
This exchange might sound casual, just a simple yes to confirm phone contact. But in bond violation terms, it's explosive. Contacting a protected party is one of the most serious breaches because it undercuts the court's very reason for bond conditions, to protect victims or witnesses. Brand's admission is short, almost resigned, suggesting he knows the consequences are unavoidable. Judges weigh admissions differently from contested hearings. A clear admission saves time but also locks the defendant into responsibility. Judge Simpson doesn't need to deliberate much. An admission equals confirmation of violation. Viewers should notice how fast this turns. Sometimes a single yes carries the weight of an entire case. This raises a question for you. If you were in Brand's shoes, would you risk making those calls knowing a no-contact order is absolute? Or is the pull of personal ties stronger than the threat of jail time?
Court will accept the defendant's admission to the violations. All right. Well, yeah, this final subject.
That's this.
No bond at this point. All right. I think his bond currently is set at no bond because of the violations or alleged violations in the case pending the hearing. Where do you want to go from here on this case?
We're asking for a preliminary examination, Judge.
You have all the discovery counsel.
Yes, Judge.
People have their witnesses available the 24th.
We'll do our best, Your Honor.
Does the 24th work for you, counsel?
It doesn't unless it's in the afternoon.
It would be all of
Right.
so
But let me look and see if I could get a better date.
we
You know
have
what? I'll take the 24th and I'll switch the other date.
so preliminary examination will be set in person June 24th, 2025, 9 a.m. before Judge Freshour. Bond will continue as no bond is bond. I will revoke his bond at this time.
Here comes the hammer. Judge Simpson moves decisively. Brand's bond is revoked. That means immediate custody. No release pending further proceedings. Notice the sharp contrast with Buick. Earlier, Buick's bond was denied reduction, but Brand loses bond altogether. This highlights a core principle. The more serious the violation, the harsher the consequence. Courts often use bond as leverage, violate terms, lose freedom. What's compelling here is defense counsel's plea to allow limited phone calls with Brand's mother. The argument his mother is uninvolved and poses no risk. But Judge Simpson flatly denies this. citing the defendant's prior misuse of phone privileges. It's a textbook example of how one bad decision taints all future requests. Viewers, here's a question for you. Should judges ever make exceptions for family contact when trust is already broken, or does fairness require zero tolerance once rules are violated?
Right, Judge, there is one thing though that I wanted to address on.
Yes.
My client wanted to be able to call his mother. His mother has no connection to the complaining witness in this case. Nor is he going to use her as a method of communication.
People.
Your Honor, I would just object that we can't guarantee that she would use her third party to communicate. I don't mind just having.
Yeah, I'm not going to allow that to happen at this point in time. I normally wouldn't have a concern about that, but the defendant has already decided that he wishes to engage in activities that would violate the privilege that he has to call people, talk to people while he's incarcerated. So I'm not going to change that. His phone privileges are revoked in their entirety. All right.
Thank you, Judge.
Thank you, Your Honor.
He's filling in. Court does call the case People versus Holly Brown.
Ashley Lonnie for the people.
Good afternoon, Your Honor. Sam Bernstein here for Holly Brown.
And this was her motion to set aside her plea. I would indicate, and I don't know if counsel's aware, we received a violation.
That is correct.
That,
So,
are you aware of the violation?
yes, Your Honor.
All right. And she's not here.
Enter Holly Brown's case, a stark reminder that showing up is half the battle in court. Her attorney moves to set aside her plea, but she fails to appear. In courtroom dynamics, absence is fatal. Judges interpret no-shows as disrespect, unreliability, or outright defiance. Simpson responds accordingly. Motion denied, warrant issued, bond revoked. This sequence illustrates why attendance is non-negotiable. Justice cannot function without the parties present. Brown's absence transforms a potentially winnable motion into a guaranteed loss. For viewers, this is courtroom drama stripped bare. One missing chair alters everything, and it sparks the bigger question: was her absence negligence, fear, or a calculated gamble? If you had a chance to overturn a plea that could decide your future, would you risk skipping court? That tension between fear of judgment and duty to appear shows how personal struggles can sabotage legal strategies instantly.
That's correct, Your Honor.
Doesn't look like it, Judge.
Here, the people of this time would ask the court to not defend its motion to withdraw her plea. That doesn't mean she can't refile it later and issue a bench warrant.
I would just ask, instead of just denying it, I mean, it just doesn't need to go forward at this time, and she can renotice it if appropriate later.
Well, here's part of the problem. Part of the problem is this was sent to Judge Freshour for sentencing.
Okay.
She files her motion to withdraw. Since I took the plea, it came back to me. And it's been sitting here while we've been trying to address her motion to withdraw the plea.
If it gets denied, it goes back to Judge
It
Freshour.
goes back.
I'd ask for it to be denied, Your Honor. Thank you. That's smart.
So what I'm going to do is, defendant having failed to appear, motion to withdraw plea is denied. And warrant will continue out. Her bond will be set at no bound at this point because I had issued a warrant based upon the violation that had occurred. All right.
All righty.
Okay.
Thank you, Your Honor.
I don't know why. Court does call the case People versus Anton Brooks.
Joseph and Goldman, on behalf of the people, Your Honor.
And good afternoon, Your Honor. Assistant Public Defender, Shanazi Kyriacou, on behalf of Mr. Anton Brooks, who's approaching. Mr. Brooks, state your name for the record, please.
Anton Brooks. Your motion.
Yes, Your Honor.
Here we witness the delicate balance between a defendant's right to counsel and the court's need to move cases forward. Brooks requests more time to secure private representation after struggling to find an available attorney. Judges walk a tightrope here, grant too many delays and justice stalls, deny them, and a defendant may proceed without proper defense. Notice how the prosecution seizes this moment to highlight non-compliance with a court order. This is a strategic move. While the defense frames Brooks as a struggling citizen trying to exercise rights, the prosecution frames him as evasive and non-compliant. It's two narratives battling for the judge's perception. Ultimately, Simpson raises Brooks' bond, signaling caution over compassion. How much leniency should courts give to defendants genuinely struggling to hire counsel? Should deadlines bend, or does justice require strict adherence even when money and access are barriers?
At the last court date,
Excuse me. Have a seat.
Thank you, Judge.
Go ahead, sir.
At the last court date, the defendant requested adjournment to retain private counsel after receiving a copy of the people's motion. I don't believe that that has occurred. I believe that counsel after proceedings for which is people rely on their plea for the court, but I don't want to speak for the defendant, but the status of his desire to take private counsel.
Thank you very much for that, Mr. Bengali. Your Honor, I was going to request an adjournment on behalf of my client. I did speak with him. He states that he has not been able to retain an attorney, Judge. He indicates to me that he's reached out to two different attorneys. They've both said that their caseloads are too heavy to take on anything additional right now. He, at the last hearing, did request a month, hoping that we would get that. The court gave us 2 weeks to see how far we've come. He states he only has his mother and his significant other. He has the funds to retain, or he can gather the funds to retain an attorney, but he just has not been able to secure a person who's willing to take on his matter. So he's asking that the court adjourn today and give him a little bit more time to continue working on that. And I was just going to say, in regard to the people's motion, Judge, I know that, there is currently a search warrant that has been effectuated. I have explained to my client what could potentially happen, and the people listed that out in their motion. He does understand that. However, Judge, there's no urgency. It's not as if this is a situation where more time would, possibly negatively impact any results that they may get from that when it's received, Judge.
I will slightly disagree with counsel with respect in that it is a valid court order when it is defining compliance with that court order. We'd ask for remand in this matter for such time as a sample is willing to provide. And also, and have written notice from the people that each subsequent refusal to provide a sample could potentially result in an additional charge. And the case law that we're relying on is indicated in the brief, copy of that, and it's discussed with their clients. Cannot make any guarantees that should there be additional refusals, that there would not be additional charges.
What do you have this month?
And Judge, it should be noted that there is an additional case. It's an AWIM case that my office conflicted off of. That is the subsequent case. That is the case that was being investigated when the search warrant was given. So he is, do you know what your bond on the AWIM case is?
I think 100.
It's $100,000 cash or surety bond on that matter, which he is not able to pay.
That he's also held on.
That is correct, Judge.
What I will do in this case is his bond currently is 10,000 cash surety. Or is it 10?
It's 10%.
Okay.
Okay. All right. And granted, I have not heard the motion, so and defendant seeking counsel. So I won't remand till he's compliant, but I do not think, given his behavior in not complying, at least at this point, with a valid order of the court, that I'm going to increase his bond in this case to $1,000 cash surety. I will adjourn the motion. How much more time is he going to need?
How much more time do you think you'll need?
Past the 26th.
Judge, he's asking for past the 26th of June, 2 weeks, Your Honor. Right? What's today?
26th of June. He thinks he can get it accomplished by then.
That's what he's hopeful for, yeah, Judge.
And I will adjourn. Actually, I think we're set for probable cause and the motion. Probable cause and the motion will be adjourned to 26, 2025, 3 p.m.
Thank you, Your Honor. Okay.
Thank you, Your Honor.
Mhm.
Court does call the case People versus Allen Blue.
Thank you, Judge. Good afternoon.
For the people.
Lawrence Margolis on behalf of Mr. Blue. Please state your name, sir.
Alan David Blue.
Judge, this is the date and time for PCC. We've been working with Ms. Douglas and everybody at the Veterans Court. And I believe this will be a referral to the Veterans Court. So I've been advised that I thought he was accepted, but I think there's more formalities that have to occur. So I'm seeking shortest adjournment you can give us, because
Alan Blue's case provides a striking contrast to the prior defendants. Instead of revocations or denials, the court discusses referral to Veterans Court, a specialized program recognizing the unique challenges faced by military veterans. This is rehabilitation-focused justice in action. Judge Simpson responds pragmatically, weighing calendar constraints but ultimately agreeing to an adjournment. Veterans courts often emphasize treatment, structure, and accountability over pure punishment, acknowledging trauma and service-related struggles. For viewers, this is a glimpse of a different justice philosophy, restorative rather than punitive. While Buick and Brand face heavy restrictions, Blue's case signals hope for tailored solutions. Do you believe specialized courts for veterans, drug offenders, or mental health cases create fairness, or do they risk unequal treatment by carving out exceptions? This moment shows how law adapts or struggles to adapt to the diverse realities of those who enter the courtroom.
I've spoken with Mr. Ashenfelter, I've spoken with Judge Valvo, I've spoken with Paul Graveline, and they all are very positive on Mr. Blue and his entry into the court. We signed the paperwork. He met with Mr. Ashenfelter yesterday, or 2 days ago. 2 days ago. So I guess we're seeking a week.
Well, I only have because of Juneteenth, I only have the 17th, which is becoming a loaded docket. And that's on a Tuesday, and I have the 26th. So
17 works for me. Is that?
I'm here every time.
So the 17th,
Perfect.
you think you can get?
Yeah. And if not, I'll let the court.
Well, so the motion for the PCC, as well as the motion for modification of bond, will be adjourned to 17th, 2025, 9 a.m.
Thank you, Judge.
Thank you.
See you later. Your Honor, would I be able just to provide the court's copy to keep in the file if the court may be ready of the VA referral, or do you want that at a different time? Because I prepared the form thinking that I was going to be referred, that we were going to be referred today. I'll send it a different time.
Court does call the case of People versus Neil Kessler.
Thanks, Judge.
Jacob Kennedy, on behalf of the people, Your Honor.
Lawrence H. Margolis with and on behalf of Mr. Kessler, who is approaching, please state your name, sir.
Neil Kessler.
We are prepared, or we're asking the court to set it for an exam date.
All right, what about your motion?
We'd like to approach on that if Your Honor would permit us to. On a case that he no longer has because he's that interested in the, how the defendant is doing. So I think it's important to let the court know he's doing very well. Thank you for that bench conference, Your Honor. So we're seeking an exam date, and Mr. Kennedy and I are going to get together and see if we can come up with a stipulation to present to the court in a timely fashion on the motion to modify bond.
So
Kessler's hearing centers on bond modification, with defense seeking internet access and tether adjustments. Judge Simpson delivers a split ruling, denying internet use but leaving the door open for a stipulated curfew tether arrangement. This showcases judicial discretion, absolute denials where risk is high, internet access often tied to cyber-related offenses, but conditional flexibility when compromise maintains safety. What's interesting here is the negotiation-like tone. Both sides are tasked with drafting stipulations for approval. This reveals how courts sometimes act more like mediators, balancing state security concerns with defendants' daily life needs. For viewers, it's a moment of courtroom nuance. Justice is not always a blunt hammer. Sometimes it's a carefully tuned scale.
Let's do it this way so that there's some finality to the ruling. Your motion to modify bond with reference to the issues regarding internet, I'm going to deny that portion of the motion.
Understood.
With respect to the issue of the house arrest tether, the court would entertain a stipulated order allowing for some type of limit on this defendant from the home on a curfew kind of basis. And that, so I will rely upon counsel to then prepare that order and submit it to the court prior to the exam date.
Thank you, Judge.
Right. You have all of the discovery, Mr. Margolis.
We do.
Would people have their witnesses available the 24th?
Yes.
All right. Preliminary examination in person will be set June 24th, 2025, 9 a.m. That is before Judge
Washington.
Washington. Bond continue.
Thank you, Judge.
Thank you. Who's on this? Oh, there he is over there. Court does call the case of the People versus Dantes Williams.
Alexander, on behalf of the people, Your Honor.
Brian Bowling on behalf of Mr. Williams. The podium, state your name for the record.
Name Dantes Marquise Bernard Williams.
Thank you.
Judge, we're here for a bond violation hearing. Based on my discussion with Mr. Williams yesterday, he would like to move forward with that hearing.
All right, very good. You can have a seat. Was the okay? Yes, she is. All right. And as I understand it, this is a part of a remand back from circuit court because of the, I think, the addition or the attempt to add an additional charge of
Assault with a dangerous weapon. I think.
Yeah, felonious assault. This is part of that hearing. This is the bond part of it.
I apologize. We missed that, and I have a moment before pass this matter for a second.
Sure. How much time are you gonna need?
I don't think long,
I don't know.
but you know.
Whenever a
famous last
defense attorney says that to me, why don't we take him back and then
Okay.
you guys.
Famous last words, Judge.
Yes,
You know how-
exactly. And then the court is standing brief recess. Just let somebody know that you're ready for me and I'll come back out.
All right.
Counsel, can I just to also let you know, I'm handling the bond portion of this because it's quicker to deal with the bond if it came before me. That prelim itself would have to then be set before Judge Barr, who had the original hearing. So,
Okay.
you know, so that is going to take place at a later.
Yeah, no, I assume so, Judge. Thank you.
Thank you, Your Honor.
Court does recall the case of the people versus Dantes Williams. Counsel.
Oops, sorry, Your Honor.
Go ahead.
And on behalf of the people,
Brian Bowling, on behalf of Mr. Williams, just state your name for the record again, please.
Dantes Marquise Bernard Williams.
Thank you. All right, I've had an opportunity to speak with counsel regarding the case, and there may be, I'm saying, a plea agreement that will be worked out. And here's the only problem, which I think is both in this court's mind beneficial to the people as well as the defendant. But the order which sent this case back down to the district court, I'm unclear as to the charges you were bound over on, whether the jurisdiction on those charges still lies with the circuit court. And that down here, we could do nothing. So what I'm going to do is I'm going to adjourn it to the 17th, about 5 days out from now. I'm going to make a call with the permission of counsel to Judge Slay to try to make sure and clarify what her reading of her order is as opposed to my own reading. And if necessary, implore her, if necessary, to give us a new order if we need to, so that everything comes back so we can take care of it down here. Okay? That probably made no sense to you whatsoever, did it?
Yeah, but no, but yeah, it's like it could have been dealt with an circuit. So I
In
was
circuit court, I mean?
yes, sir. So
Let me just tell you, I don't know what happened up there. All I know is it came back down to this court for a bond motion and for a preliminary examination on additional charges. So then I'm only going to be handling the bond motion part of it. So, but counsel to have been working really hard to come up with something that would be a good solution, I think. And so to give that a shot for it to happen, I'm willing to adjourn this out 5 days, do what I can do to try to clarify it all and see if we can get it done down here. Okay. If you have questions on it, ask for your attorney. He's a smart guy. All right. Okay. So bond will continue as it is right now. I'll adjourn this out to June 17, 2025, 9 a.m. All right. Thank you, folks.
thank you, Your Honor.
We end with Dante Williams' bond motion. The case is tangled in jurisdictional confusion between district and circuit court, yet Judge Simpson demonstrates judicial patience. Instead of rushing to judgment, he adjourns and commits to clarifying orders with another judge. This reveals a critical truth: justice is not always swift or clean, but it requires precision. A wrong jurisdictional call could invalidate proceedings entirely. Williams' case underscores the system's complexity: multiple courts, overlapping rulings, and the judge's role as both decision-maker and procedural navigator. Today's docket revealed the spectrum of justice under Judge Simpson. From Buick's failed bond plea, Brand's revoked freedom, and Brown's no-show disaster, to Brooks' struggles with counsel, Blue's referral to Veterans Court, Kessler's negotiated tether, and Williams' jurisdictional limbo, the courtroom delivered tension, lessons, and human drama at every turn. The key takeaway: bond is more than money. It's trust, and once broken, it's hard to repair. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.